Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip in the continuation of the series of the changes to the 2019 Georgia Association of Realtor contract forms. Today's tip has to do with the two forms that you are going to use in a contract when the clients choose to have a closing attorney as the holder of the earnest money. So the forms I'm going to talk about today, again, all of the forms have been renumbered. So these forms are now F510 and F511. So let's do a little bit of background. For whatever reason, buyers and sellers are deciding to have a closing attorney as the holder of the earnest money in certain contracts, rather than one of the brokers, the listing broker or the selling broker. So the problem was, prior to 2 years ago, the buyers are giving these closing attorneys earnest money and then expecting the closing attorney to fulfill the terms of the holder of the earnest money per the contract. The issue was, nowhere on the contract does the closing attorney sign. The closing attorney is not a party to the contract. They don't sign anywhere. They don't agree to fulfill the responsibilities of holder. They don't agree to do any of the issues if there is a dispute over the disbursement of the earnest money upon termination, and just a whole lot of issues. Now, of course, your closing attorneys can't be illegal with the money, but they were not bound by the terms of the contract. So a couple years ago, GAR recognized this fact and came up with a form, I believe at the time it was F84, for the closing attorneys to actually sign, indicating that they did agree to fulfill the responsibilities of holder of the earnest money if they were named as holder. The issue was a couple years ago that agents tend to work different hours than closing attorneys. So agents are trying to go under contract in the evenings and on the weekends and so forth and so on, when they could not get a closing attorney's signature on this required form. Therefore, it was keeping the parties from going binding because you couldn't get the attorney's signature on that form. So then last year, so 2 years ago is when they first came up with this form that had the attorney sign. Definitely move in the right direction. Then last year, GAR recognized that it was having this form as part of the contract was preventing parties from going binding in a timely manner. So last year, GAR came up with two forms, F84A and F84B. One of the forms just named a closing attorney as the holder of the earnest money so that the buyer and the seller could go binding without having to get that attorney's signature. Then F84B was another form that the buyer had to get the closing attorney's signature on in order for it to be complete. The closing attorney needed to sign and needed to agree to fulfill the responsibilities of holder. But it was a separate form. Again, so that the parties could go binding. There were all kinds of issues with those two forms, F84A and F84B. There was all sorts of default language for the buyer, all sorts of termination rights for the seller, simply having to do with not timely getting the closing attorney's signature. And it was just creating all sorts of issues. So in a move to try and still narrow down this issue and try to get it a little bit more in line with trying to keep the parties in contract and have the closing attorney agree to act as holder of the earnest money, GAR has revamped both these forms, the one that the parties use to go binding, naming a closing attorney as the holder of the earnest money, as well as the form where the closing attorney signs. Also, last year, there was a place where the closing attorney could charge for the services of being the escrow agent, and there were all kinds of issues with that as well. So let me talk about the forms, and then we'll talk a little bit more about this topic in general. So on the actual purchase and sale agreement, in the section where you name the holder of the earnest money. It does specifically state that if you do name a closing attorney as the holder of the earnest money, you absolutely are required to also have these two additional forms as part of the contract. F510, closing attorney acting as holder of earnest money, and that is an exhibit to the contract that the buyers would go holding, that the buyer and seller would go binding with. And then an agreement of the closing attorney to serve as holder of the escrow money. The escrow agreement, that's not an exhibit because that's signed after the binding agreement date. So, number one, if you name the closing attorney, you have to use these forms. And then the other thing is that the buyer, I'm not going to read you paragraph by paragraph. Please take a look at these forms. I'm just going to talk about them in general. The buyer must timely deliver the contract and the form, the agreement form for the closing attorney to sign in a timely manner. And that has now been changed from, it used to say 1 business day, and now it has 2 business days. So 2 business days from binding agreement date, the buyer is responsible for getting the contract and that agreement, blank agreement form, escrow agreement, to the closing attorney to sign. They also, GAR has removed all the default language. There was a ton of default language in there if the buyer didn't timely get these forms to the closing attorney and the attorney didn't sign. So they removed all that default language. Then it states that the closing attorney must agree to be the holder of the earnest money within 3 business days of receiving that form. So if you're counting in general what the forms allow, we're looking at 5 business days from binding agreement date, because the buyer has 2 business days from binding agreement date to get the escrow agreement to the attorney, and then the attorney has 3 business days from receipt to sign it and agree to be the holder of the earnest money. So potentially, contractually, we're looking at 5 business days from the binding agreement date before we even have an agreed upon holder of the earnest money. Again, some of those issues aren't changes. They're just, the paragraphs have just been a little bit renumbered in the forms. Now, this is a big change. In Form F510, it does state that the earnest money must be wired to the closing attorney. And we've discussed in previous videos the issues with wiring funds and cyber fraud and so forth and so on. So one of the things to be sure of is that the closing attorney named as holder of the earnest money does get the wiring instructions to the buyer. So just a tip in general for any time that a buyer is wiring earnest money, either to a closing attorney named as holder or to one of the brokers. Agents, y'all need to make sure to allow for a little bit longer time frame when you are negotiating the remittance period for the buyer to remit the earnest money funds to the holder, if it's going to be a wire, to allow for that holder to mail in the U.S. mail or overnight by courier service, the wire instructions to that buyer, since email wire instructions are all sorts of issues with cyber fraud. Again, those are other videos. But anyway, back to this form. So it specifically states that earnest money will be wired to closing attorney acting as holder. So again, that is potentially some I don't want to say issues, but again, the buyer is going to have to get those wiring instructions from the closing attorney that is named as holder. Now, this form, F510, is an exhibit to the contract. So you know that an exhibit will supersede the purchase and sale agreement. So on the front page in paragraph A of the purchase and sale agreement, if the buyer and the seller agree that the form of the earnest money will be in check or certified funds or something to that matter, if you are using this exhibit, it changes to a wire. Again, the exhibit supersedes the purchase and sale. Then it states that if the closing attorney fails to become the holder of the trust funds, in other words, if the closing attorney does not sign that escrow agreement in a timely manner, then the alternate holder that is named, and there is a fill in the blank space, and it is paragraph 7 of the form, you must name either the listing broker or the selling broker as the alternate holder of the earnest money. That is so vital. Do not leave that blank, because it specifically states that if the closing attorney named as holder does not timely agree to become the closing attorney, then the alternate holder automatically becomes the holder of the earnest money, and all parties agree to sign whatever forms or do whatever is necessary to now get the earnest money to the holder that is the holder of the funds per the contract. So absolutely, y'all must identify the alternate holder. So basically, that is the nature of the exhibit that the parties would use to go binding, naming a closing attorney as holder. Again, they took out any of the fees that the closing attorney can take, and they took out all that default language, changed it to a wire, and changed the time frames. Now, then the sister form or brother form, the companion form that goes with this, is this agreement of the closing attorney to serve as the holder of the earnest money. And this is form F511. And a lot of the verbiage in this form reiterates what was in the other form. It specifically states that when the closing attorney does sign, the closing attorney does agree to fulfill all of the responsibilities of the holder as outlined in the purchase and sale agreement, to deposit the money, to disperse the money, to give notice if it was not timely received, or if the money was not honored, if the wire, for whatever reason, was not honored by the bank, to disperse the money if there is a dispute based on a reasonable interpretation of the contract, or to interplead the funds, so forth and so on. All of those responsibilities of the holder, once the closing attorney signs, it says that the closing attorney agrees to fulfill all of those responsibilities. It also states that once signed, the closing attorney is responsible for getting the signed form back to the buyer and the seller. Again, it reiterates that the closing attorney must agree within the 3 business days after receiving the form and the contract. And again, it reiterates failure of the closing attorney to timely agree to be holder. The holder of the funds automatically reverts to the alternate holder that was named in form F510. So please, please, please take a look at that. Just a few notes in general about naming a closing attorney as holder of the escrow funds. First and foremost, make sure that whichever party is choosing to have the closing attorney as the holder of the funds, please have a discussion with that closing attorney prior to naming them as holder of the funds. Some closing attorneys will gladly accept those responsibilities and are well versed in the contract and the responsibilities of the holder. Some of them do not want to be named the holder of the earnest money. So definitely consult with the closing attorney prior to naming them. Understand, make sure that they know, get a copy of the contract and know that there will be wired funds hitting their account. And they're going to have to know that because they're going to have to get the wire instructions to the buyer directly. As I've mentioned, as an agent, do not be the intermediary in the instructions, the wire instructions from a closing attorney to any of the parties. Again, if you do name the closing attorney as the holder, you absolutely must use forms F510 and F511. The buyer is responsible, again, for getting those wire instructions. Couple of things just in general. Bottom line, your closing attorneys, unless they hold a real estate license, they are not bound by GREC. The Georgia Real Estate Commission has no authority over enforcing license laws on closing attorneys because they don't hold a license. Now, again, the closing attorneys have an IOLTA account, which is basically a trust account for the trust funds, and they can't be illegal or mishandle somebody's funds, but they are not held to the same GREC license laws that agents are and that brokers are and brokerage firms are. Also, GREC holds you as the agent responsible for the handling of earnest money when it is written in a contract and your name is on that contract. Bottom line, both agents, both selling agent and listing agent, need to follow up with the holder of the earnest money, regardless of if that holder is the listing broker, the selling broker, or closing attorney, or the seller, whomever is named as the holder of the earnest money. Both agents are responsible for following up. Did you receive the funds? Did you deposit the funds? Did you receive the funds? Did you deposit the funds? Did you receive the funds? Did you deposit the funds? You listing agents, you need to make sure that those funds have been received and deposited, because those do become liquidated damages should the buyer default on the contract for the seller. And you buyer's agents, you want to make sure that the buyer does fulfill their contractual obligation and remit the funds, good funds, to the holder per the contract, so they don't go into default. Again, just be very careful with the wire instructions and follow up. Now, there are some situations where the closing attorney is required to be the holder of the earnest money. For example, certain short sale listings and certain REO listings. But other than that, it's definitely worth a discussion with the buyer and the seller and the closing attorney if the buyer and seller choose to name them as the holder of the funds, rather than either the listing broker or the selling broker. And additionally, there are some brokers that choose to not hold the escrow funds, don't have an escrow account, or their escrow account has been temporarily put on hold by the real estate commission, or just choose to not deal with trust funds. But regardless, these are issues that need to be investigated before naming whichever party as the holder of the earnest money. Thank you guys so much. Hope this contract tip helped you out. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.